In this case, we represented a woman named Teresa Donahue, who was in her early 80s. She was admitted to Muirwood's Memory Care. The facility was dealing with the COVID pandemic, and after several months, the family was really cut off from communication and access to the facility. During that time, Miss Donahue's condition started to decline and she started to fall. What the family didn't know was also during that time, there was a huge shortage of management and staff at the facility, and the condition of care that was being provided went downhill really fast. On March 20th of 21, Miss Donahue had her fourth fall, in which she suffered a hip fracture. She became bedbound, developed bed sores, lost weight, declined, and in April of 22, she died.
The defendants had destroyed a lot of their staffing documents, which were basically the center of our allegations related to understaffing. And so we really had to rely on deposition testimony and then the testimony at trial of not only their own staff who admitted that they were understaffed, but also our clients who witnessed other residents walking around in soiled diapers. We also relied on testimony from agents of the state, from community care licensing.
Our clients in this case, Kelly Tanier and Raymond Donahue, were two of Teresa Donahue's living children. They were very close with their mother. And so we were with them and actively in litigation as Miss Donahue was dying and as they were grieving her loss. One thing that was ultimately really compelling for the jury were videos that Kelly had taken of her mom just kind of hanging out, laughing, which really brought Teresa to life in a way that I don't think it otherwise would have been possible. We tried the case the first time in August and September of 23, and that case ended with a hung jury. And our client, especially Kelly, really just wanted to get justice for her mom. It was never about the money. It was sort of became a no-brainer that we were going to try it again.
The pandemic was used as an excuse throughout the trial, throughout both trials actually. And with the first one, I believe the jury really listened to them in terms of their defense that they were excused by the pandemic. But for the second one, again, we really said, yes, it was a pandemic, but they still had choices and they still chose not to take those right steps.
One of the things that struck me at the end of the closing was just talking to the jury about why this case matters. And I think once people really sat with themselves and started to think about that and imagine if it was their parent, if it was their grandma, allowing no justice for these people just because they can't speak and fight for themselves, it just seemed like there really wasn't another choice for the jury but to find for us.
So in terms of the verdict, Karman in her closing had a very unique mathematical equation. So it was basically a daily calculation of the amount of days that she was in pain and suffering. And so they came up with a number that was a little over $3.25 million. The main chunk of it was Miss Donahue's pain and suffering. And then we also had $300,000 in wrongful death damages for Kelly and Raymond Donahue.
We stood in the courtroom when the jury came back, and I'll never forget it. The first question was just, were the defendants negligent? And when the foreperson read the answer that it was yes, that moment for our client was all that she needed. She almost fell down. She was so overwhelmed with emotion and validation. It didn't matter what any of the other answers were to Kelly, but that, and I'll never forget that the rest of my life. But then we ran on. They kept reading, and we heard that we got elder abuse, that we got recklessness, that we got oppression, and that there would be a phase 2 to the trial. It's been really an honor and a privilege to work with Kelsey and to work with these amazing clients who never were in it for the money, who really just wanted to hold a bad actor accountable and do the right thing. And so while with some other clients it may be terrible to still be sort of in limbo, she's still just happy she got her day in court and got the jury's validation that her mom was wronged.
When Oliver Armstrong's mother contacted us, she was in a desperate need to find an attorney that would represent her son. And when Oliver came into our office, he told a very compelling story about getting very drunk at a conference and having a friend hail him a cab to take him back home to Berkeley. Somehow he ended up being dropped at 16th and Mission at 2 a.m, where shortly thereafter he was mugged by 3 to 4 people and left for dead on the sidewalk, unconscious. Thereafter, he had brain surgery at Highland Hospital for an epidural hematoma. Some of the really difficult hurdles was that he had been assaulted 5 minutes after he had been dropped off. Over the next 3 years, we were ultimately able to identify the driver. The defense had posited that and contended throughout trial that our client had changed his mind and didn't want to go to Berkeley at 2 a.m. Instead, he wanted to keep the party going and wanted to go to 16th and Mission to get a prostitute and drugs. They maintained this position all the way through motions in limine, in which we were able to win some motions to exclude all that nonsense because there just wasn't any evidence of it.
So Mr. Armstrong, before this injury, was a vice president of product management. After he had the subdural hematoma, he wasn't able to maintain those hours and focus anymore. He actually had to do speech therapy. He had to learn how to hold utensils to eat again. He was able to miraculously overcome a lot of that. A lot of the doctors agreed that he made an amazing recovery, just not 100%. And so we had to convey to the jury at trial that this is actually a man who's very seriously injured, when we knew that during the amount of time that he'd be on the witness stand, it just wouldn't be apparent that he had a brain injury. So we ended up calling a lot of friends and family to come in on Zoom and testify. The defense contention on all this was that he could get a little bit more treatment and he'd just be fine. As it turned out, Mr. Armstrong actually had done most of that treatment, and it didn't substantially improve him. The jury was definitely on our side with those issues, awarded the vast majority of his wage loss, both past and future.
You know, it was a guy who was going to earn over $2 million in his lifetime, and the non-economic damages have to be at least 10 times that, given that he's living now with a brain injury, and we heard all these witnesses talk about how he's a different person now. So I left him with the number of 20 million, and the jury awarded a total of five. And so the total verdict came to almost $8 million. A lot of the closing revolved around this idea that under the common carrier duty, the highest degree of care was you do what you do for your friend. If your friend's drunk and he gets in the car, you take him home. You don't drop him at 16th and Mission at 2 a.m. Hopefully, we've had an impact on the cab industry in the city, and they will take better care to advise their drivers to take their people to a destination or a place that actually is safe, like maybe a hotel lobby or a police station.
Mr. Armstrong is a stand-up guy. He's a Marine veteran, hard worker, good with his family and friends. I was hearing things from the defense attorney, literally, like, your client is a scumbag, which really motivated us to show to the jury, to prove to the defense counsel, you guys are wrong about him.
And I think the anger that motivated us for a defense attorney who met our guy at deposition one time, trying to tell us who our client was when we had spent, 100 hours with the guy. It's like somebody attacking your friend at that point.
I got a call, I think from Bryan. It might have been from Joseph, but ultimately all three of us talked about this case that had been pending for quite some time. There was a civil rights case, which is not the normal type of case I handle. It just felt so like so many cases I had done before, but when I was doing criminal defense work, and how there was never anything I could do about that kind of bad behavior short of getting a case dismissed, which didn't put the client in any better position. So here was an opportunity to actually represent amazing clients who had been, wronged in really horrible ways that have been going on for, hundreds of years.
Our 3 clients were a mother and her 2 then teenage daughters who had driven all night from Las Vegas and stopped at a Starbucks in Castro Valley. They'd driven all night because the eldest daughter was set to take her first college exam at Berkeley Community College. They're approached by 2 white deputies. Our clients are African American, and within 10 minutes, there's a call for backup. They're handcuffed and placed in the back of 3 separate patrol cars for 90 minutes. If this was a white mother and 2 teenage white daughters, never would have happened. And that was really the essence of this case.
These types of cases where somebody didn't get beaten or killed or imprisoned for years weren't the kind of cases that people would take as a civil rights case, because where are the damages? This case recognized the historical harm that has been done to our communities from decades, centuries of discrimination, of unequal treatment. And this jury took that opportunity to say, yeah, we would like it to end here. We are going to fully and fairly value the harm that's been done to the Loggervales, which is also a societal harm, and that's how they got ultimately to their number.
A year and a half or so into the case, we're sent to a mandatory settlement conference, and the defense attorney sent an email saying that they have decided to make the generous offer of $2,500 per plaintiff. After lengthy deliberations, our clients turned down that offer, and we proceeded to trial. The jury awarded $2.75 million per plaintiff for a total of $8.25 million. They appealed to the Ninth Circuit and lost. They finally said, okay, what's it going to take to settle? And we calculated the interest, the fees, the costs, the judgment to the penny, and it was $11,266,404.62.
What I hope, and I think all of us hope, is that this is something that continues on well beyond the Loggervale case, where there is somebody who has suffered this kind of discrimination, this unequal treatment, unfairly, right? Like, we should be better than that now. And a clear message hopefully has been sent to law enforcement that that's the expectation.
This case hopefully now serves as a benchmark for other civil rights attorneys, that they can say, hey, when they're dealing with other public entities, these cases have real value.
The easy thing for the Loggervales to do was to have this bad experience and then just move on, because it was past for them, right? This was not making their life easier. But they actually took the harder step, and they picked up the phone, they called Joseph, they called Bryan, they said, this feels really wrong, and we believe in our system of justice and that it can correct this. And to be vindicated in that way, I think, is incredibly gratifying for them. It really just goes to their character, and what an incredible group of women these are that are willing to do the hard thing, really, for everybody else.
This was a truly horrifying thing that happened. A family trying to go talk to the school principal about their daughter being bullied resulted in the entire family being assaulted in the parking lot. The mom beat unconscious while her 4-month-old baby is still strapped into the car seat, and the school security guard is just standing there doing nothing.
We were representing a mother who spoke no English, and so being able to help her tell her story was essential in terms of the jury being able to connect with her. Maria suffered greatly, not just on the day of the incident, but she had severe PTSD. At many points as she was trying to heal from what happened, she was essentially agoraphobic and would not leave her home. Her daughter, Esmeralda, spoke perfect English. She was a straight A student, highly accomplished young woman. But these were embarrassing things for both of them to talk about. So getting them to feel comfortable about telling their stories was a huge challenge. The defense counsel fought us tooth and nail from the very beginning of the case, filing a demurrer to our initial complaint.
They were fighting liability. They were suggesting that our client Esmeralda, wanted to fight this bully.
So there was never any real offer here. We were going to trial in this case no matter what, and that was fine with us.
Yeah. I don't know that it was fine with them at the end, but
Well, there you go.
this wasn't just a public entity case. This was a case in which we were suing a school district. Most of the people in the community who are going to be on that jury pool were very sensitive to the fact that school districts are severely underfunded.
Once they were past that threshold of understanding this really was completely on the school district, at that point they had the trust in us to award full and fair damages to our clients. There was one really important unguarded moment with a vice principal at the school. She tells the police on body camera there's a history between these two.
I don't think you can understate how huge that was, because the district's position was, how could we have known that there was any kind of beef between these two girls? No one ever told us. We never saw anything. It was so devastating to the district's defense, and I think to defense counsel's credibility.
I remain convinced to this day that if Maria Jimenez had been a wealthy Caucasian mother in an affluent school district, we never would have had to go to trial in this case. I was very blunt with this jury in discussing damages, that the arguments being made by opposing counsel, both with regard to comparative fault and also trying to diminish damages as it applied to Maria, were classic examples of implicit bias. I think one of the things we're most proud of is that this verdict was 99% non-economic damages.
One other aspect of damages that I think it didn't occur to me until we were actually in trial. How does this woman who has been through this parent another child through school? As a parent, as a mom, was just like a whole new world of hurt that this woman was going to go through, and a huge loss for her, because for Esmeralda, before this incident, Maria had been an extremely active parent, and that was something that she was never going to be able to do for her other daughter.
The total verdict in this case for both plaintiffs was just over $9.5 million. Of course, it's total shock when you get a verdict like that, and so you have to remain kind of stoic to make sure that the jurors don't see how you're really thinking or feeling.
I didn't get that far. I think I just got to holy fucking shit.
Yeah.
Holy fucking shit. Holy fucking shit. And then I started to tear up, and I saw the forewoman who was also tearing up, and then I turned to Maria, who was also tearing up, and it was euphoric. And it was righteous. It was righteous. It felt like a real moment of justice.
The favorite part for me of hearing the verdict be read was actually turning over to my right and seeing Esmeralda. You could see that release in her, that just feeling of relief that, the jury had heard her, had believed her, and had given her justice. And that to me was what I'll always remember about hearing that verdict being read.
Yeah, that was a moment.